Hello, everyone. We're just I know, like just having some technical difficulty. Just give us 2 minutes. Sorry for the inconvenience. We'll be back. I know, like just 2 minutes. We're just figuring it out. Sorry about that. Hi, Sanjana.
Are you able to hear me?
Yeah, it's all good.
Right. Sorry, all. We were just experiencing some technical difficulties. Glad to have everyone here. So the session is intended to be a Q&A. Not restricted to any one particular topic. Mhm. So, Ms. Kennedy, I would like to get started with some of the questions that we have from our audience.
Sure, Sanjana, go ahead, please.
So we have one question that says USCIS denied my H-1B, saying my degree is not directly related to the job, but I have 10 years of work experience. Does the experience count?
Yeah. Hello, everyone. Good evening. Thanks for joining. This matters a lot. All that we are trying to do over here is to support the community with so many questions, clarifications. We are very unsure about what's the right answer. And this is not going to establish an attorney client relationship over here to say that. And then we are glad that me and Sanjana, who is part of our team of the Law Offices of Mary Kennedy, will be supporting you with your questions. For the first question from Sanjana about our if there is an unrelated degree, and then what is why I'm getting denied. So when we look back, the modernization rule that was from January 2025, that was one of the when it compares to the specialty occupation. But I'm wondering if it's an extension, right, Sanjana? So it shouldn't be something of a concern. That's what the rule says. Might be, unless we go into the detail of the denial, we have very limited knowledge to address about it. But as long as it's an extension, it's understandably the modernization as well states that you should be continuing even though it's a different degree. Any other opinion from you, Sanjana? What do you agree on that?
Thank you for the explanation, Ms. Kennedy. We can basically proceed with an experience-based evaluation, essentially equivalating your work experience to a US bachelor's degree in order to qualify yourself for the H-1B. As Ms. Kennedy stated, there are a lot of factors that are involved, including the quality of your experience letters, how well you can substantiate your previous work experience. But it is possible to utilize your work experience in order to gain a degree equivalency.
Yeah, thank you.
So, Ms. Kennedy, another question that I have here is my company was acquired by another company. Does my H-1B automatically transfer to the new employer, or do we need to file a new petition?
Okay, so that's again another like how subjective question. So it depends on many other criteria, but the basic understanding is when there is a merger M&A contracts that is in place. So in that case, most likely, if it's under the same ownership, it's not a completely a change of like even the EIN number of which employer, like even the company that's getting merged with, they are going to be the deciding factor. So many things are subjective. But however, on a side that where I have to say is most likely there is not needed an transfer. But then when you go for an extension or any other place that's going to be, then it has to be clarified through proper documentations.
Thank you, Ms. Kennedy. My H-1B petition has a different job title than what I am actually doing at work. Is that a problem if FDNS shows up, and how do I handle this?
Yeah, that's a very good question, and that's more common what's going on right now. So the FDNS officer's intention for his visit is definitely related to your H-1B petition. I do understand practically you will be having a title of a software developer or a programmer, whereas your client place might call you as a consultant because you're a third-party employee. So many different titles could be of your place when you're with the client. However, the title that you have to inform the FDNS officer, and we insist again and again, you have to be having your LCA along with you, and then you have to specify that's the title that you're going to be providing it for the FDNS officer.
Thank you, Ms. Kennedy. And we've been seeing this a lot with the recent site visits where small mismatches between the LCA, the petition, and what the employee is answering tends to trigger further scrutiny on the petition. And we're seeing these notices of intent to revoke as well. Employees and employers being educated on what is listed on their H-1B petition is definitely the need of the hour. We have a question here. I received a notice to appear. What is the immediate next step that I should take?
So the notice to appear can be for various reasons. The common one that's happening now is you're getting terminated from an employer, and you're in the 60 days grace period. However, your employer would have withdrawn it. See, legally speaking, you are eligible to continue with your grace period of the 60 days. That's a memo that is with the USCIS. However, it happens that USCIS has started issuing an NTA for those some of those beneficiaries. So what they have to do is, then this no NTA is notice to appear before a judge. They would have given every details on that. All that you have to do is find the help of a local attorney and then go and appear before the judge. That's very important for you not to ignore it or leave the country without doing that. So very important that you have to do that.
Thank you, Ms. Kennedy. We have a question that says, my medicals have expired. What is the option for me to do interfiling, or should I wait for the RFE?
Absolutely, you have to go for an interfiling. The reason is even taking a chance minimally to go again and do that, we would definitely recommend it, right, Sanjana? The reason being the visa numbers being available. As you all know, now we are in the early April. So the year 2026, the visa numbers are getting expired by September. So USCIS is taking every step to process if your final action dates are current or it's expected to be current in the coming months. So if your medical is supposed to be expired and you know about it, there is a process called interfiling, and we have successfully done it. There are other opinions about it, but however, every chance you have to expedite to get your capture your visa numbers, that matters a lot, and you should be doing it.
Thank you, Ms. Kennedy. We have a situation here from someone who intends to move to an F1 visa. Um, but they already have a priority date of 2016. Their question seems to be, what are the implications of moving to an F1 visa, particularly later down the line if they want to add their dependents, or what are the implications for international travel being on F1, and sort of having that immigrant intent associated with an I-485 application? Is it advisable to move to F1?
So, if I'm understanding that question, so they do have 485 that has been filed. Is that what it is, Sanjana?
If they are to file a 485 application down the line.
Okay, so this is how it is: the F1 or the F2 till your 485 has been filed. You are, with an approval of an I-140 itself, you have presented the intent to the government that you are planning on to continue your stay. So definitely it's going to be a questionable place anytime after your I-140 is approved, you're going for your F1 student visa or associated with that an F2 visa as well. So you are always have to prove the intent to the government on that part of it. So be prepared for it. And some of them comes under the place where the parents have filed for it and they become eligible, the reason being they are below 21. So for them it's little more so that we are able to substantiate it. Hey, they have a I-140 that is approved for them being a child which is like who are lesser than 21. However, the parents, it's about the parents, and then they do have an education that they are enrolled in a college, so they have to continue and they are aging out, so it becomes like a little hard till your 485 is filed. If you have filed your 485, then after that there is no plan that you could be approved of an F1. So in that case, we guide you just to keep it as a parallelly and non-immigrant visa status, we are strongly advising, if you become, if you are, if you, there is a chance that you're going to be filing your 485 based on the date of filing, then there is going to be a gap, whether the final action date will get current, or if you're planning to be aging out or your children getting aging out, then in that case, we strongly say that, file your F1 on a premium processing prior to the 485. That's what we would say that, and, advise our clients.
Thank you, Ms. Kennedy. And we will also be putting our firm's contact details in the chat in case anyone would like to reach out for a more case-specific consultation. We have one more question here where it says, my I-140 was approved 4 years ago, but my employer recently withdrew it. Can I keep my priority date for a future employer?
Oh, that's a good question. So, when coming back to this priority date, it's very important after your I-140 has been filed and then approved, and then 180 days had passed after the approval of the I-140, then your priority date is yours, unless there are other reasons. But however, you retain the priority date. The employer withdrawing that after the 180 days, and then, or any time, it should not affect you. So anytime you're moving on to your other employer, let it be on an EB2 or EB1A or EB1C, you should be good enough to take the priority date with you wherever you're moving on.
Thank you, Ms. Kennedy. We have a question that says, my daughter is 17 and moving to college this fall. My EB2 priority date is January 2017. When should I apply for her F1?
Can you just repeat it quickly, Sanjana?
Of course, my daughter is 17 and moving to college this fall. My EB2 priority date is January 2017. When should I apply for F1?
All right, yeah, this is two different questions. The 2017 is anticipated, but I'm not very sure with, even with the 2026 October, where we are looking for to the spillover of the visa numbers, but still with that January 17 to the is like little more to be asked for. So in that case, keeping only your F1, we also have posted the common questions on the video of our YouTube channel. So one of them I addressed was about H4 or an F1. Keeping in mind, just making it very minimal. So the answer will be, what kind of if it's an F1, the advantage of an F1 is, if she can complete the first two semesters or the third, fourth semester, depending on the school, she will be eligible for a CPT. However, that's the only benefit being on the F1. But being on the H4 gives her the benefit of in-state tuitions and other, the local eligibility of her. So I would recommend, unless you have a very strong reason to move on to an F1, do not do it. Or there are certain schools where they won't take an H4 students, they want only an F1 international students. So that's something that you should personally consider. If not, I would recommend to have her on an H4 visa. And as I said in my prior question, there is a possibility, and if it's getting closer to it, then in that case, like say you have a data filing that might come up for your child to be filed for, then in that case, to be on the safer side, you can keep your F1 filed prior to filing your 485. That's what I would do.
Thank you for that clarification, Ms. Kennedy. Uh, I see a question here that says, I used my advanced parole to travel, but my H-1B visa stamp is still valid. Did I abandon my H-1B visa by using my advanced parole?
No, that's not right. So there was an opinion, I think, very far long before. So anyone being on a H-1B, whenever you go out of country and then come back on the advance parole, then you had activated your EAD. That's what we were, like earlier point of understanding. However, it's not correct. So you do have your like advanced parole, even if you use it and enter back without going for a stamping, you're 100% continuing. You can continue on the H1B after your travel as well.
When I-485 is current, do we need to switch F1 kid back to H4?
No, actually, the only concern that happens is when you're traveling out of country, then in that case, and your child has to go for a visa stamping, then it becomes a questionable place for them with the 485 filed. And then, as I said earlier, the intent to, the F1 doesn't have a dual intent. So in that case, it becomes harder for them to substantiate when you go for a consulate stamping. However, we would recommend to wait for the advance parole after the filing of the 485 if you're going to be traveling out of country and also want to retain the F1 status. It's a little more definitely difficult. I wouldn't say complicated, difficult. So I would definitely recommend in that case to avoid traveling if you have to maintain both the status. See, some of them are in this scenarios going to be filing the date based on the data filing. So it's not going to be your children's age are not locked. We all know about it when you have an older children. I do see that so many of you are knowledgeable about that part of it. So then in that case, then it is going to be something you have to consider whether a travel is needed and then whether you have an advance parole that is approved so that you can return back on the advance parole rather than relying on the visa. So these are all something that you have to plan it out before your travel.
Thank you, Ms. Kennedy. My I-485 was filed a couple of years ago, and I recently got arrested for a minor traffic violation. Do I need to update USCIS and interfile anything to my form I-485, or do I address this if it comes up at the time of interview?
Actually, this is a very subjective question. I'm not going to be addressed it in an open call. So it's something that you have to discuss with your attorney and then have their advice on that.
So, we collected a few questions prior to this live session, and a lot of them are pertaining to wage levels pertaining to H-1B. Um, what are the implications of having a wage level one petition? I see one specific question here that says, my employer filed my H-1B under wage level one, but I have been promoted. At what point do we need to amend the petition?
So this is an H1B question, Sanjana.
That's right, Ms. Kennedy.
All right. Okay. Actually, so the H1B has been filed, and then they have been promoted, and then they want to know whether there is an amendment that's needed. Correct?
That's right.
Okay, so definitely depends on the job duties and the responsibilities. If it's the same level, or it's just sometimes it's a very minimal variation. However, if there is a change of title and then even your wages has been reflecting that the responsibility has been added, because level two wages we say that defined, develop, and all those just minimally speaking about. Whereas when you talk about the level three wages, the same software developer, however, it has its own managing the team and all those. That definitely requires you to go for an amendment. And that too, now with all these FDNS visits that happening, I definitely want every one of you to take complete attention. There are so many changes that's happening. You could have also known about this Department of Labor's in this one that's coming up. That's a proposal that's on the Federal Register, and there is going to be a substantial changes, which was all happening. So you need to really take attention. We see a lot of noise after the FDNS visit. That's all happening. On a overall, there is a huge increase in that, and now we have known about this USCIS update on the policy update. I think it was yesterday or day before yesterday. Sanjana, you want to go ahead quickly on those
Mhm.
minimally when we are able to say that, talk about it?
Of course, Ms. Kennedy. So there was an update from USCIS recently regarding just increased vetting of petitions. on an overall basis. So we would definitely encourage all employers and employees to uh, read up on the terms of their LCA if they're noticing any discrepancies between their actual job description and what is being performed at work when compared to the LCA. If there are any discrepancies, consider filing an amendment or exploring the possibility of filing one as soon as possible.
Yes, I know USCIS is also planning on to do an vetting officer separately for this purpose alone. It's not that I'm always come from a place where compliance matters a lot. So no matter what, so it's your responsibility. Even the employers, any local meetings or anywhere I go to, even before talking about anything on the immigration, I keep insisting. If you're an employer, please, this is the time that you need to take care of every compliance. It's not about you alone, the employee who has relied on his career on the company and the organization. So keeping that, like it's also the responsibility comes as an individual who's holding the H1B. Definitely, understand what's your rights, what is your LCA, what's your job responsibilities. And there are places where you can take some time to ask the officer, even with an FDNS officer, ask them to send it as an email. So there is not much of a miscommunication between the officer understanding your language or your conversations. Rather than that, writing recording of it is very, very important for each one of you. That's as a minimal as such, but that's very important for you to keep that in mind. So with that in place, if you are moving, don't assume that this is all something I am, I know my friend has been doing it. This everything is new. As said, USCIS meeting has been seriously considered in the social media. You have to keep in public whenever your application or petition has been applied with the USCIS. That has all now become mandatory. That's not anymore a choice.
Thank you, Ms. Kennedy. And as you had mentioned, something that we're seeing a lot is FDNS officers coming for these site visits and essentially requesting the employee to answer these questions on the spot. It is absolutely permissible to ask them for more time or ask for these questions over an email, to ask for a list of documentation that you need to provide. Um, the officers are flexible. It is not a requirement that you answer or provide their documentation that they're requesting right on the spot. It's always better to involve an attorney as well, and create as much of a paper trail as possible while handling these FDNS visits.
Yeah, thank you for that, Sanjana. I think we started like 9-10 minutes late, so we can extend it for another 10 minutes. There are some other questions, very interesting questions. That's on the chat. If we can go through quickly and address it as well.
James Kennedy, we applied for H-1B, H-4 EAD extension together, but on regular process on the first week of May 2025. The H-1B got approved in September, but the H-4 is still pending. We raised tickets, but no response, Vermont Service Center.
Yeah, unfortunately, this is a situation I do understand. When you say look at it, almost it's like 10 months or 11 months that has gone. That's becoming common with the Vermont Service Center, especially. And so, yeah, the other way, if you had passed your processing timeline, which is listed on the USCI's website, definitely you can raise an e-request. At least your folder will come up to the level of, the officer's attention. That's something we always recommend. Be alert about it so that you can raise the e-request, and then it comes up to a place where they are looking at your folder. And the next one is to approach a congressman's office. So they're very helpful recently, or whoever we work with, even locally we do. That's yours is now where the place you are in. Approach them, and all that they wanted is it's a service that is being provided. They do have an immigration department. And definitely, and added to that, I want to say here is if you have your priority dates, that's all on the final action dates, please, the first step is to approach your local congressman before the visa dates gets retrogressed. That's very important for you. to go ahead and request your congressman's office for their support in helping you get your green card. They all that they ask is like a privacy statement release, and they communicate with your officer, and there are many more success on that.
Thank you, Ms. Kennedy. And yes, we see this as a valuable route, especially since it removes a lot of the red tape between you as an applicant and the USCIS and opens up a channel of communication for you to get in touch with the officer handling your case and get the answers that you are looking for. Along these lines, we have a question. My I-485 is pending for 2 years. I'm exploring the option of filing a mandamus lawsuit. What are your thoughts on this, Ms. Kennedy?
If it's really pending and your final action dates are current, you should be doing it. I have seen much more success on that, and definitely this is time that you need to real moving forward for that. That's what I would say. As I said, it's something that you should be exploring that option.
Thank you, Ms. Kennedy. My kid got payment for honorarium work. It got reported on the 1099. How to fix this issue? We have handled similar cases to this. It is quite subjective as well. But Ms. Kennedy, would you be able to answer this, or would they need to go for a
Yeah, I
consultation?
think like I understand, I got your reference of it, Sanjana. But then we took the help of a CPA firm, and then we helped them out on that part of it. It's nothing to do with immigration. It's about like it's more of an tax liability. So we would recommend to talk to a CPA, and they will be able to fix that.
Thank you, Ms. Kennedy. I'm just pulling up some more of the questions that we have here.
Mhm.
My US citizen spouse and I have been married for 2 years, but we live in different states due to our work. Um, how do we approach this, and will USCIS question the validity of our marriage? Also, a very case-specific question, but there are certain things that you can do to strengthen the application for USCIS. Ms. Kennedy, would you like to speak on this?
Oh, yeah, right. So just quickly, can you repeat the question, Sanjana?
My spouse and I have been married for 2 years, but we live in different states due to work. Will USCIS question the validity of our marriage?
So it depends on the reasoning. If one of you are on a H4 and a H4 EAD, also that's not something the USCIS is going to be questioning the intention. However, if it's going to be a family-based green card on the 485, definitely that's going to be something you have to justify why, what, but it's doable. On the employment based, it's understandable to different the couples being in a genuine marriage relationship and also working from different states practically. But obviously there will be some kind of a common visits in between, and all those can be substantiated when there is a purpose, or you are called for an interview, or where you're going to be substantiated is something that we have to know about it to discuss more in detail.
Thank you, Ms. Kennedy. Um, Another question on the same lines. H4 and DAD were applied in January 2025, query raised in February 2026, still no progress. What would be my next step? Again, if an expedite request has not been successful, if you have tried contacting USCIS, if there's a compelling reason, your local congressman should be able to assist you, provided that you can give them the documentation.
Yes, that's correct. Yeah, definitely. Like the writ of mandamus is something that you have to go for it.
When I have multiple I-140 petitions, how do I make sure that USCIS gets my priority date right when I file my green card application?
Right. See, when the 485J that's going to be associated with your filing of the 485 reflects at the first time of filing, correct? on which I-140 you're associated with. We have handled like, 4 or 5 of them or more than that in some cases, but however, we will be able to substantiate it along with the 485 filing. So the what do you call, something that happens is only at the time when you would have downgraded because your other EB3 priority could have been moving forward. So in that case, you would have downgraded and then filed an interfiling on the 485J based on the EB3. So then you would have seen in the 3 years, some of you would have filed it in 2022 when the dates were moving forward very quickly on the EB3. So that's where we see that definitely you need to find an attorney to help you out, support you. Right now, I know, with all intention of good faith, I'm saying this, you need to really look into it because there is multiple times that you could have been going back and forth. Our office have experienced it. So now don't decide on to go ahead and file another 485 thinking that that's getting processed. No, that's not going to help you. The reason being, any 485 that's getting filed right now has its own processing timeline. That doesn't matter even if it's on the final action dates and you earlier had a 485. So you need to really talk with an attorney, understand if there is a 485 interfiling is needed through the 485J, because USCIS has given very clear instructions, and we have seen it when it's connected to the proper filing of your I-140, depending on the priority dates, they are able to adjudicate it. Don't worry, even if you have any numbers, all that matters is what's the latest on the interfiling. You have done it, and then if you see that that has been rightly done, then you have to take the next steps that we advised earlier.
Thank you, Ms. Kennedy. Um, we are looking out for a couple more
Like maybe
questions.
another 4 minutes, and then
Mhm.
we end the session. So the last question, and then probably a last 1 minute to talk about us, and then how do we want to support the immigrant community. Anything majorly missed out here, or if there is any follow-ups, we'll definitely try our best. If you can leave an email or something, we will try our best to reply you back.
We have one question here. My wife's H4 EAD received an RFE. The reason for RFE was taking biometrics at the ASC center. Any idea how long it will take to get an appointment date?
It depends on the local ASC center. We don't have much delays, but it's very interesting that people are going for it, and then it's delaying the whole process of the getting the EAD more than the usual delay of the processing. It's like earlier it was a mandatory biometric. However, this was connected to the national security. However, a lot more of delay we are seeing it. But the one thing is we don't see substantial delay in getting the biometric center's appointment. Not more than a week that we are able to get it actually.
Thank you, Ms. Kennedy. When applying for I-485, should we apply EAD and AP as well, or continue on H-1B? What are the pros and cons?
Definitely, I would encourage you to apply for the advanced parole and the EAD. No matter what, continuing your H1B is very important. We do understand that parallelly, but EAD has its own benefit, and I would definitely recommend you, even though you're paying extra fees, and the advanced parole is something like situations like this. This will be the best help you will have to do it for you. So that's very important. Please, anytime you are, if there is a premium processing for your petition or an application, even if it's an F1 or H1B, things are changing very quickly. So that's the money that you're investing for that to get it processed sooner, especially if you're filing your extensions before this wage increase. If it's going to be in June, we are also planning on to do another the wage increase proposal by the Department of Labor. And so you should be doing it, filing it under premium processing and get it approved within the 3 years. And the last one, most of you are on H1B. So with all attention, I'm saying this, there is a possibility when you're filing an amend, like a H4 and the H4 EAD, prior to your 180 days as well. I know like you will be losing some few months filing as an amendment come extension, but you need to talk to your employer, and so the delay is very huge, and so many of them are not have to discontinue their employment because the EAD is not able to be continued. And also not only that, it's like, so you would have been relying on the health insurance and other details, and there's no way any expedited reasoning has been given for an H4 EAD extension on an expedited process. Practically, that's not at all possible.
Thank you, Ms. Kennedy. So we have put our firm's email address in our chat box. We will definitely get back to some of these queries, which are more case specific. If you can drop us an email, we will direct you to a consultation. Um, Ms. Kennedy, do you have any closing thoughts before we wind up for the day? I know this has been a very valuable session for us, and we greatly value the time of everyone who has taken out time from their day to join today.
Yeah, thank you, Sanjana. That's always there as the team to support me in this process, in this journey. Not only Sanjana and me, there is a group of people who had been supporting us, and it's a long day, honestly speaking. But then, all that for me, I honestly value and feel is wherever I could be of any support, I want to do this. With that intention, we started this. Please let us know if you can spread around or subscribe to our channel. The only intention is I don't care about much about likes or anything, but I really come from a place where giving back and educating our people is very important for me. So we'll continue to do that, and your feedbacks is also very important. If you can send a quick note, let it be appreciating us or helping us to improve what could be the possibilities, we definitely value it. That makes us keep encouraged, and changes that we can adopt in the coming months. We are planning to continue this on live webinar with all those questions more often, with a very specific timeline that we can also give it to you. Thank you so much. I really enjoy anything I could speak about immigration. Thank you all. Thank you for joining. I really appreciate it, because it's not only for you. It matters someone that you can listen to and being part of this, the journey we are all in. Thank you. Appreciate it. Vanakkam.
Thank you, everyone. Thank you for joining, and have a great rest of your day. Thank you all.
Nice. मुझे चाल ना पगला பேசிட்டு இருக்கேனா